Welcome to the Regulatory Transparency Project's fourth branch podcast series. All expressions of opinion are those of the speaker.
Hello, and welcome to the Federalist Society's Regulatory Transparency Project's fourth branch podcast. My name is Libby Dickinson, and I am an assistant director with RTP and the Federalist Society's practice groups. As a reminder, all opinions expressed are those of the speakers and not of the Federalist Society. Today, we are joined by a fantastic group of tech and legal experts to discuss the recent Supreme Court decision in Free Speech Coalition v. Paxton. Our speakers today include Ash Kazarian, Senior Legal Fellow with the Future of Free Speech at Vanderbilt University, Claire Morrell, Fellow at the Ethics and Public Policy Center, and Bailey Sanchez, the Deputy Director of U.S. Legislation at the Future of Privacy Forum. Our moderator today is Jennifer Huddleston, Senior Fellow of Technology Policy at the Cato Institute. Thank you all so much for joining us today. I'll start by handing things over to Jennifer.
Thank you so much. And thank you for this great panel for basically getting the band back together, so to speak. As some regular listeners of this podcast may know, probably a few months ago now, we had a similar podcast with Claire and Bailey and Shoshana Weissman instead of Ash at that point to discuss the oral arguments in the Free Speech Coalition v. Paxton case. This case recently came down from the Supreme Court. At issue was a Texas law that was aimed at protecting young people online from potentially sexual content considered harmful to children. So this includes things like obscenity and pornography, but there was a lot of debate about, was the law actually broader than that? Some very specifics of this law, which is a similar model that we've seen in other states. So now that we know what the court actually thinks about some of the issues that came up in our previous podcast as it relates to the potential impact on adult speech rights, the potential concerns around privacy, as well as, was this issue specific to young people's access to this type of potential sexual or pornographic content, or were we going to see the court engage in a broader discussion of some of young people's access to the internet more generally? I'm excited to kind of get this group of experts back together to hear more thoughts. So I guess just to start off with, as I mentioned, we all were discussing this shortly after oral arguments. We now have a decision written by Justice Thomas in favor of upholding the Texas law. Is this what you expected to see in this case, and why or why not? And Claire, I'll start with you.
You maybe saw me grinning through my camera. No, I will say that I was cautiously optimistic that this is how the court was going to come down. I was in the courtroom for oral arguments, and my sense of where the justices were leaning was that they were really trying to actually allow a path for Texas and other states to legislate in this area. They were recognizing the compelling interest states have in protecting children from online obscenity, and they were really trying to make it clear that we don't want to have two different constitutional regimes, one that governs the real world and one that governs the online world. And so there was a lot of talk about how these age verification laws we've accepted in the real world for decades now in brick and mortar stores, and that this Texas law was applying that type of law to the online space. And so I was thrilled personally to see the ruling come down this way, in particular to see that the court applied intermediate scrutiny. And we can get into this more details about why I think that's actually significant, even beyond just this Texas law. But I was really encouraged to see the court recognizing, Justice Thomas wrote in the opinion that this work of states needing to balance the free speech rights of adults with their compelling interest in protecting children from obscenity required the more nuanced work of intermediate scrutiny, and that the burden, and I want to just acknowledge, because I know others on this call will probably disagree with my take on this ruling, but I want to acknowledge that the court was really clear that there was an incidental burden on adults' rights to speech in this case. It didn't say that there was no burden. It recognized there was a burden, but that it was incidental. And part of that is that they recognized, this law was different than the laws at issue in the past precedents of Ashcroft and Reno, that this law was not banning adults from being able to post this type of content or even to be able to access it. It was just requiring, this Texas law is just requiring adults to verify their age before accessing, which is a hurdle that is now, given the technology available, easy for adults to overcome, but is actually an effective hurdle at shielding children from this obscene content. And I just want to note that the opinion says it is misleading in the extreme to assume that Reno and Ashcroft spoke to the circumstances of this case simply because they both dealt with the internet as it existed in the 1990s. And they say the appropriate standard of scrutiny in the Texas case is a question that no prior decision of the court has squarely addressed. And so the decision really went into a lot of detail to distinguish this law from the laws at issue in Reno and Ashcroft, and to make clear that this law deciding the level of scrutiny to apply to this law was a circumstance that the court had never squarely taken on in either of those cases, whether age verification for pornography websites is constitutional or not. And that was the question that this case took on. And they said it deserves intermediate scrutiny and that adults have no First Amendment right to avoid age verification. And that, again, any burden on adults' First Amendment rights was incidental. And so I'm thrilled by the ruling. I could not be happier. And we can get into the other implications that I'm hoping to see from this ruling in your further questions.
Claire, can I ask, because part of Jennifer's question is just like what was surprising about this decision? I feel like there was so much discussion back in January and like leading up to this case about, rational basis or strict scrutiny. Again, listening to oral arguments, I think it was not super surprising things went this way, but I was very surprised to see the court did not apply strict scrutiny. And I find it a little bit hard to understand how they arrived at intermediate scrutiny. And I think that's a lot of what the dissent talks about, is just that, this was a clear slam dunk, strict scrutiny applies. Was it surprising to you that they arrived at the conclusion the way they did?
I have to say I was a little bit pleasantly surprised. I didn't know exactly how they were going to come down. I didn't think that they would apply rational basis. That didn't seem to be where they were leaning. But I also felt like they were really poking a lot of holes in why strict scrutiny would apply. I don't necessarily think I anticipated necessarily them applying intermediate. I was kind of curious to see if they would, apply strict scrutiny, but poke some holes in how it should apply to these types of laws. So I guess I don't ever purport to be able to predict exactly where the justices are going to come down. But I will say I was pleasantly surprised with the application of intermediate scrutiny. I didn't want to assume that that's where they would go. But I'm very glad that they did.
Bailey, you kind of jumped in there. I'm curious, you were part of our prior conversation. How did this reflect with what you thought might happen? Any specifics of the ruling that kind of stood out to you?
Yeah. So again, I think after listening to oral arguments, it felt like the court seemed to kind of like as Claire mentioned, want to figure out a path for state lawmakers to make this type of regulation work. I think what surprised me, besides the intermediate scrutiny being applied, was that I think Justice Thomas seemed to kind of just take it as a given that the technology is in place, it works, it's good, there's no issues. I don't think there was actually really much discussion of age verification technology at all. There was pieces here and there, but a lot of the discussion focused on the specific facts of this being porn and porn being harmful to kids, and the state's important interest in protecting kids from harmful content or perceived harmful content. But I think the court kind of hand waved away any concerns raised by advocates about concerns with age verification or likelihood of data breaches or anything. Justice Thomas kind of reasoned that, the porn industry has always been subject to kind of social stigma, and to protect the interests of the consumers of that porn companies have like a really high incentive to make sure that age verification is safe and secure. But also, you know, you can only do so much to prevent a data breach. Sometimes they just happen. And I'm not saying that they happen like all the time and they're very commonplace, but I think it surprised me just how quickly the court kind of like put aside those arguments on the technology, because I think whether or not the technology is effective and works and is minimally invasive for adults is actually really a key question here in arriving at like whether or not it survives any type of scrutiny.
Ash, I'm curious for your thoughts, and maybe you could also talk a little bit about what we saw in Justice Kagan's dissent from the court as well.
Oh, man. Okay. So I will start by saying that I was completely surprised by the decision. My prediction was that the Supreme Court was going to rule for the Free Speech Coalition, but narrowly, and leave the door open, apply strict scrutiny, and leave the door open for there will be soon enough age verification technology that would meet the privacy concerns. And so leave the door open for that, but still apply strict scrutiny. So I was obviously wrong of how the court was going to rule. I know some people who also participate in this policy and legal debate have called me out on it. I'll say, I mean, reality is reality. I will never deny it. So that's one. I want to quickly say, because we've already kind of started diving into it, because, you know, we're all very passionate and experienced in this space. We've been diving into this. And one thing I want to say, and for what it's worth, I think Justice Kagan also addresses it. So Claire mentioned the Ashcroft and Reno, as Justice Thomas said, not applying to the internet that we know today because it was different when those rulings came down. What Justice Kagan says in her dissent is, well, yes, the facts are different. That doesn't mean you get rid of strict scrutiny. You apply strict scrutiny to a different set of facts, and then you see where you arrive. And I believe she also doesn't dismiss the fact that maybe even if you applied strict scrutiny, this law would have survived the constitutional challenge. But we never got to that. Instead, we kind of, according to her and me, I would say, I mean, that's kind of a delusional sentence to put myself with Justice Kagan. But I agree with Justice Kagan that this decision pretty much not guts, but rearranges First Amendment doctrine in ways that we can't even predict we're going to have to see play out, because Reno and Ashcroft now, who knows how much they apply. And I know you have a question about that too, so I'll let you lead us there.
Yeah, so that kind of opens up the kind of question of, you know, we talked a little bit about what was said in this case, but of course the next phase of any Supreme Court ruling is kind of what does this mean? And this case occurs both as we are seeing various legal challenges work their way through the courts over perhaps some broader age verification, age appropriate design, and age assurance laws, things that either focus on aspects of the internet like social media, things that focus on the way content may be displayed on various websites, as well as laws that say look at perhaps doing age verification or age assurance at an app store or device level. You know, what it will, of course, see what the lower courts interpret this decision as. But is there anything that stood out to you guys as how broad or how narrow the court may intend for this decision to be reached? Is this, at the end of the day, really a decision that is about protecting young people from pornography, or did it give any broader indications as to how the court might think about age verification and what would be a more general context?
I'm happy. Oh, sorry.
Yeah, go ahead, Ash. You start.
I'll be short. I think on its first read, it reads formally narrow, right? It limited to sexual content harmful to minors, specifically target websites that have 33% or 1/3 of its content, preserves adults' access in theory. But I think functionally it is broad because it erodes the boundary between strict and intermediate scrutiny. As I said, I'm not sure how Reno and Ashcroft apply and exist now, and we're going to have to see how courts play that out. I think it also invents a new, as a First Amendment lawyer, it's like slightly exciting, but not really. It invents a new category of partially protected speech. So we're going to have to figure out what that means. So that means, again, courts are going to run, there are all of these groups and interests and folks who are going to try and test this theory. And then it also, I think, creates a roadmap for broader regulation, right? Every time Supreme Court rules on any issue, it gives tools and structures to everyone who cares and wants to participate in this public policy and legal debate on how to structure ways to reach their goals. So I think on its face, you can say they try to be narrow. And I think they were still narrow. They narrowed a bit even what the Fifth Circuit was doing, right? They weren't doing rational basis. But at the same time, I think it's functionally broad, and we're going to see a lot of litigation trying to figure out what's next for free speech in a lot of different areas.
Can I jump in before Claire
Absolutely,
goes? Yeah, I think my conclusion is pretty similar to Ash's. Like, I think like the court spends quite a bit of time talking about like, you know, like the obscene and harmful nature of like porn specifically. It seems like Justice Thomas, I think, is perhaps a little skeptical that that is like protected speech at all, even though I think Justice Kagan concludes that like a lot of the speech at issue here is like protected speech. But I think to Ash's point, like what I take away from this case is that like, you know, if I was like a law professor trying to explain like what the rule here is or what the takeaways are and how this would apply to a different set of facts, I find it like a little confusing and a little hard to parse because like, you know, the court held that this regulates access to material deemed harmful to minors, not content. But to me, this is a law that like very clearly is about regulating content. So I think when we take away the porn component to it and try to apply it to a different set of facts, it's just hard to me how to decide, you know, what's only about access and what's about content. I understand, I think the distinctions that they made with Reno and Ashcroft, that those laws are about kind of just, you know, prohibiting content at all. But I feel like this is maybe a distinction without difference, and they kind of like functionally arrive at the same conclusion. So Claire, I'd be interested to hear your take and like, you know, how you think this applies going forward, given that like you're a bit more happy about the decision.
I know. I'm sorry. I can't hide my happiness. I'll just start by saying, I think in terms of like the implications for what this court means for other laws, I think by applying intermediate scrutiny, you know, the court says like the First Amendment imposes no freestanding under-inclusiveness limitation, and that Texas need not address all aspects of a problem in one fell swoop. So part of the kind of historic nature of this decision was that by not applying strict scrutiny, they were kind of setting the least restrictive means test aside. And that just opens up a lot more options for state legislatures and Congress, that they have actually more latitude and flexibility to address the problem of protecting kids from online obscenity. I'd be really cautious to broaden it beyond that type of law. Like, again, the compelling state interest to protect kids from online obscenity, because I think some people seem very eager to try to say, oh, this will now apply to age verification for social media or app stores. While I might personally be in favor of some of those laws, I think different arguments will have to be made because, like we were just talking about, this case is really narrow to the question of, is it constitutional to restrict the access to obscene content online? And the question really at issue was about age verification and whether or not that is constitutional. And again, the court was really clear that adults have no First Amendment right to avoid age verification. That's what Justice Thomas wrote in the opinion, but they meant in the context of restricting access to online obscenity. And so I think some people are taking that sentence out of context and saying, this is great. This means we have this for social media and app stores too. And I'm like, it could mean that, but there's just different arguments will have to be made because, again, the thrust of the argument in this case was about protecting children from online obscenity, restricting the access to those kinds of websites. So I guess I'm in two parts. I'll just wrap it up by saying I think it's a yes to giving states more flexibility and freedom to legislate in the area of protecting kids from online obscenity, that they could pass more laws and regulations in this area to address different aspects of the problem. The court was basically saying states could go after this problem from multiple angles, since they no longer have the limitation of having to prove that a single law is the least restrictive means. But in terms of applying that to broader internet regulation, social media app stores, I think that's still untested because that wasn't at issue in this case. And some people might want to read into it. I'm a little bit more cautious to kind of take this case for the facts of this case, instead of being really quick to take like one sentence from the opinion that says, adults have no First Amendment right to avoid age verification and apply that to other contexts. Justice Thomas meant that in the context of restricting access to obscenity online, obscenity websites. And so I think we'll have to it remains to be seen what broader ramifications this case will have or not.
I feel like part of the reason it's getting taken out of context, though, is maybe how the court approached the decision. Because, like Justice Thomas focused on not just obscenity, but obscenity for children. And I think that was perhaps a different understanding of how like the Supreme Court has addressed like obscenity jurisprudence. It's been like some sort of objective, reasonable person standard, essentially. I don't remember the exact wording. But I think like obscenity for children is probably a much lower bar. And I think when I think about potential implications of this case, I think about, how would a particular state define what's obscene for children? Does that include like LGBTQ content? Does that include information on like gender affirming care? That might be protected speech for adults, but is that something that like a particular state might consider obscene for children? And I take your point, and like I agree that like I think the facts of this case seem to be very narrow, but just based on like the court's arguments that they made and how they really laid out things, I feel like it's just not a very like clean, easy to apply decision.
And we might disagree. Oh, go ahead.
Oh, go ahead, Claire.
No, I was just saying.
Go ahead.
Well, I was just going to say to Bailey, like, and we might disagree on that. Like, I personally am in favor of states having more flexibility to define what is obscene to minors. And again, in a law that's not saying adults can't post that type of content or can't access that type of content. It's not a ban on that type of content. It just puts this hurdle of age verification in place. And so I'm actually for states having more flexibility to define that. I understand that the terms, again, yes, Justice Thomas uses that term of obsceneness to minors a lot. And so I do think that they are. And other cases have recognized that states actually have more latitude in defining obsceneness to minors. But that again, like I really do think this case is all about access, and that's what the court said, that what is that issue is this activity of age verification, and that again adults don't have a First Amendment right to avoid that activity, and that's why they applied intermediate. And I realize we might disagree on the merits of that. But I am actually for states having a little bit more flexibility of how to define that and still having adults be able to access any of that material once they provide age verification. But sorry, Ash, I interrupted you.
Oh, no, you're good. This is perfect because I just wanted to close the loop on this question by saying, I think our answers, even if we disagree on a lot of the things, our answer proves my point that there's going to be a lot of new interpretation, and this decision is functionally broad because one way or another, there's going to be a lot of testing of the new waters of First Amendment doctrine.
Mm-hmm.
Well, one of the things in terms of First Amendment doctrine and potential applications this brings up is the fact that this was a facial challenge to this law, not an as applied challenge. And there's been also a lot of debate to the conversation that was going on here about how broadly this law could be interpreted and what options might be available to websites that are perhaps more general websites that may meet the threshold, but that's not the majority of their content. Is it possible to age verify only for access to certain portions of a website, or would a website have to age verify for everything? How broadly, as was kind of alluded to, is content, sexual content that's not deemed harmful to minors going to be interpreted by states? Is this going to be something seen in kind of that traditional fictional pornographic content, or does it open the possibility of broader definitions? I'm curious to kind of our panel of experts here. What do you think this means with regards to kind of ongoing discourse we've seen about facial versus as applied challenges? Do you think that this conversation will continue or change any once we start to see a potential enforcement of the law?
I mean, that's hard to predict. I will say, while it was, a facial challenge, the Texas law, because the Fifth Circuit stayed the district court injunction, the Texas law was allowed to go into effect, while this appeal up to the Supreme Court was ongoing. And so the Texas law took effect like November 14th, I think, of 2023. And the state attorney general used that to sue a bunch of the major pornography websites. Pornhub decided rather than comply to just leave the state. Others they reached a settlement agreement with where they agreed to implement certain age verification measures. And so to me, I'm actually excited because it proves the point of the necessity of these laws, that the implementation actually means that kids are more effectively being protected, that the states actually have an ability to enforce the laws. So I don't know if I can speak to predicting the facial versus the facts of challenge, how that will play out. But it is interesting to start seeing some of these laws actually take effect. So I'm kind of curious to see what happens.
Asher Bailey, You look like you're about to say something.
I thought, so that was discussed a little bit in the opinion. I thought the fact that this was a pre-enforcement facial challenge, or I guess technically it was kind of enforce a facial challenge, would come up more in the decision than it did. I feel like ever since the Moody decision last year, I feel like that has really been something that I've been paying close attention to, because, this case actually was not brought by Net Choice, but quite a few of these online safety laws are brought by Net Choice. I noticed that their Net Choice lawsuit against Maryland's AADC, that was, I think that was a facial challenge and an as applied challenge because the law went into effect. And I feel like the court is signaling again that they are not going to want to definitively rule on things while there's not a very robust record. And so I think while the Texas law can go into effect, I'm interested to see how that will work in other states, because again, I think over a dozen states have this type of law, but they're not all exactly like a copy and paste. There might be some variance in how the state defines what is obscene, what percentage you need to have of porn on your site to be in scope. And so I think this is definitely something to watch. I don't know if I have any clear takeaways, but it's an issue that I think is under discussed but important.
Great question, Jennifer. I think I'm still also processing, but I pulled up the decision and I think it does two things. It narrows facial challenges for kind of two things. First one being the incidental burden. And then the second one being, I think there's a footnote that cites United States v. Hansen and says a facial First Amendment challenge succeeds only if a substantial number of laws applications are unconstitutional. So this means implication for future, but facial challenges for online age verification have gotten much harder. You plaintiffs would have to show that the majority of applications involve protected speech, and then that the burden is substantial across those applications, and then that the statute cannot be narrowly construed or saved by judicial interpretation. And I think that's a steep climb, right? If I'm right about this, again, we don't know what happens. So I think as applied litigation will become the fallback route.
As you said, we're still very much in the kind of immediate after a decision, we don't know what happens phase. But needless to say, this decision has spurred a lot of discourse. What do you think is the biggest misunderstanding about what the court ruled in this particular case?
That's a great question. I'm just processing it.
I know. I'm thinking about it because I also feel like I'm kind of on the winning side here. So I'm I guess obviously you all may have more concerns about how the ruling's misunderstood. I would just say, I think by people who disagree with me, I think sometimes it's misunderstood just in general what these age verification laws are doing. And so I would just point people to the decision to just say, again, it's not saying that adults can't post or access this type of content. It's really all about whether or not the activity of age verification and requiring that of pornography websites is constitutional or not. And so I think you have to really be clear in this decision. It's not banning this speech for adults. It is just requiring age verification. And that's, I think the point that was most clear from the decision is just this concept that adults don't have a First Amendment right to avoid age verification. They have a First Amendment right to access this speech, but accessing that speech now through this Texas law and these other laws entails some type of age verification measure in order to effectively keep kids from it. So I think sometimes the purpose of the law and then this decision can be misunderstood in terms of what it's actually saying is constitutional. And so I would just say that that's something to pay attention to.
I think what is misunderstood / not really discussed that really was triggering to me was the anonymous speech aspect of it. I think the anonymous speech comes into, and its existence is now, there's a big question or creeping, clouds in the background to it, because anonymous speech has been protected since, the Federalist Papers were written under pseudonyms. There was a reason for that. And so my biggest thing that I don't think we're talking enough about as we're processing and discussing this decision is what this means for anonymous speech.
Ash, I just did a Control F because that was a great point. And the word anonymous, unless I'm spelling it wrong, is not in the decision at all. Like, again, to my point before, there really just was not a discussion of the age verification technology. I thought that would really be part of how they distinguished from Ashcroft and Reno, is just discussing how much the technology has evolved. It's much less invasive, blah, blah, blah. I feel like the court just, again, just hand waved and was like, yeah, it's different than it was before. I think an under discussed point will be that it wasn't clear to me how the court measured that it was an incidental burden. Again, it's hard to get to that, this is only incidental when there's not a very robust discussion of the technology as it applies to online. I think Justice Thomas spent a bunch of time talking about, showing your ID when you go to buy alcohol or something like that. But that is just a different process than online. I think there are definitely more privacy friendly ways of doing age verification. And I thought that would be a really interesting thing that the court could have talked about, but they did not. And I think that maybe speaks to the fact that this was a facial challenge and there just wasn't a very robust record. And I think another point that has been under discussed on that is that Justice Thomas kind of used existing industry practices as evidence that this is doable. He mentioned that for decades, porn companies have been collecting age information, which I'm not 100% sure how true that is, because I thought that was why these laws were passed in the first place. And two, I think it is interesting and something to watch that just industry practices, industry self-regulating will be used as evidence to kind of retroactively kind of justify legislation. So, I could see a world where there's some social media companies that have started to proactively take more steps in that age verification space, and perhaps a court would use that as evidence to say, if X company is doing it, why is Y company not doing it? But if there were porn companies that were doing age verification before, they might have had their own, just reasons to do it. I think OnlyFans does pretty robust, identity verification to make sure that people are above 18 when they're posting. That makes a whole lot of sense. I think Pornhub does the same for people that post. I don't think they do it necessarily for the people that are viewers. But those are very specific business reasons why they do it, not necessarily ways that align with what the Texas legislature has in mind for these types of laws.
Can I just push back really briefly? I think to me, what the point that the decision was trying to make is that adults may have a right to access this, but they don't have a right to avoid age verification, and that accessing this type of speech in the real world is actually a lot less anonymous than online. Like, I actually wish they had gone into some more specifics on the technology that's available online to actually show that it's like more anonymous to access this on the internet than it is to go to a brick and mortar store and purchase a pornographic magazine. Like, it's a lot less anonymous that you actually have to go in person and someone could identify you at that store purchasing that thing, showing your age. And so I think, again, like, I thought it was really critical that the case was trying to explain, like, we've accepted this in the real world. It's a common sense solution. We need to bring kind of our constitutional regime and the virtual world into alignment with the real world. And that was actually one of the big points that Justice Thomas pushed back against the dissent about, was that if strict scrutiny applied, it would call into question all these brick and mortar store age verification laws. And so on the point of anonymous speech, I actually think that the way that age verification is conducted online and how this law is being applied and the decision was made, it is still protecting of adults' right to anonymous speech. I realize they didn't discuss that. I wish they had gone into more of the specifics of the age verification technologies available. But I appreciated that Justice Thomas did note that age verification is even more imperative in the virtual world than the real world because it's easier to be anonymous online. He actually points that out. It's like easier for a child to pose as an adult. And so the need for age verification in the online world is actually even greater than a brick and mortar store where a cashier could probably tell roughly whether or not a person is a minor or not. So I thought he kind of made that point coming from the other side, how the anonymity online really necessitates more effective age verification. But Bailey, I will agree with you. I wish that they had actually gone into more details about the current technologies available and actually, from my side, showed that they are more privacy protecting for adults and in ways that are actually even more anonymous than purchasing obscenity in the real world would be. But that's my hot take.
So Bailey and Ash, I want to kind of ask you about this because this does seem to have been a key portion of the decision of this question of, is the internet different than online? Is the internet different than the offline world? And was this, more or less than showing your driver's license to a cashier? That certainly came up during oral arguments. I know we discussed it a bit then, but that seems to have been a big point of Justice Thomas's opinion, is seeing this or stating that he had concerns that applying strict scrutiny could undermine these other laws as well. I'm curious to your thoughts of, is there a distinction in the online and offline world here that you would have liked the court to recognize, or is this something where the online offline analogy still works?
So I think this is a really bad analogy I'm going to use, but Claire has a very strong Pokemon of like Justice Thomas, right? He's writing for majority. I have a weaker one of Justice Kagan writing for dissent, but I'm going to still play my Pokemon in this case and say millennials on the podcast. But basically what Justice Kagan says, right, and what I agree with is when you flash your ID to a store clerk, the store clerk doesn't write down your name, doesn't write down your information, doesn't store it. And that's a very big difference from what happens online. And I believe the way the law is written, it basically doesn't say anything. It doesn't require, it says the website doesn't have to retain the identifying information, but transmission of that information is not prohibited. There is no monitoring or reporting requirement, which means that when you flash your ID in online world, that the chilling of a speech and the burden that can happen with, well, what happens with my information? We just had, I think like within the last month, a huge data breach across Microsoft and other platforms. Like this constantly happens, and that doesn't happen in a brick and mortar situation. And yeah, that's why I think the facts are very different here. And I know my Pokemon is weaker because it is the dissent Pokemon. But I do think there's a very big difference. And I actually agree. Like, the technology has also changed. The internet is bigger and vaster, and our privacy is less and less protected every day. I recently went through an airport and I turned around and I saw the screen of an agent, and they just scan the face and they have all of your information right fast. You don't even have enough time to like opt out of it. And also you don't have the convenience of it. But yeah, I just think we are more and more going into that utopian Black Mirror surveillance state. And I'm going to turn it over to Bailey, who works for Future of Privacy Forum, to talk about that aspect of it. But to me, there's a big difference. And I think, yeah, focusing on brick and mortar was a way to reach the policy goal that the majority had in mind. But I don't think it's the right application.
Yeah, I think the online space is very different from the in-person space. And like to Claire's point, though, I think that you can kind of, create some like reasonable guardrails with online. Like, I don't think it needs to be like a lawless space necessarily. But I think that, looking at like the chilling effects, people just don't want to do age verification for like adult services, like under COPPA, which side note, the majority, I think this is just the fault of Congress passing too many laws with similar names. COPPA is the law that was struck down. But Justice Thomas accidentally refers to COPPA, the Children's Online Privacy Protection Act, in one part. I thought that was just like a fun nod that even the Supreme Court justices can't keep COPPA and COPPA straight. So COPPA has been in effect since 1998. And under COPPA, parents are required to give like parental consent for companies to collect their children's data. And it is a huge problem of just like doing that like verifiable parental consent, because parents, if a company, again, a very child-friendly company is like, give me your credit card or give me your ID, they just often don't want to. There's lots of like companies and like ad tech services that have like studies on like drop-off rates with doing parental consent, because it's just like kind of like an inconvenience. And it's also like a trust factor. Like a parent is like, why is my child on a website where they are asking for my personal information? So I think even in that like very like child-friendly, like safe environment, parents are very hesitant to do that. So if you think about, like a porn website, like if I went to Pornhub, there is no way that I would give Pornhub my ID or, a credit card to verify my information. And again, there's that requirement under the law that's like, don't keep the information, delete it after. But I think it's really just like a trust thing and like a chilling effect. And I think people are just going to like maybe not bother. And maybe that's actually the intention of the law. But I think that I think it's fair to say that like age verification has come a long way in the last 25 years. But I think it is a really tough argument to say that like doing it in person is exactly the same as online. Because if it was exactly the same, I think like it would be a lot more widespread and a lot more websites would be doing it.
I would just briefly say, like, unlike brick and mortar stores, because I agree, it's not exactly the same online, but online there's actually the option to have like third parties conducting the verification, so that the actual Pornhub website is not receiving any private information or personally identifying information about you, which is more privacy protecting than if you have to go to a brick and mortar store. And I mean, I actually feel like cashiers do record some of this information. I often see them type my birth date like into whatever their records are. I'm sure they have to maintain some type of records to prove that they're verifying that the person that they're selling the alcohol to is over age. So there is some record retention, but I understand what you're saying, the concerns about where is my information, who has access to it. So I'll just briefly say, like, more and more states are adopting digital IDs, this digital type of driver's license. And I know we talked about it before, but Louisiana has actually like implemented a very effective system. So much so that while Pornhub has dropped out of like 17 states, they're still doing business in Louisiana, because Louisiana has made it easy for them to conduct the verification with their digital IDs. You don't actually, no information is actually transmitted to Pornhub other than like whether or not this person is under 18, because there's a software affiliated with the digital ID called Verify You, and Pornhub, like the website itself says, do you have verify you, Louisiana. And if you do, you click a button and it basically then you open the app on your phone and just say yes or no, like, Pornhub or whatever wants to know, can we transmit to this website that you're over 18? And then that's all that the digital ID sends to Pornhub is just this person is an adult. No information about me, my birthday, my name, anything personal to me is not actually given to Pornhub itself. So I do think more and more states are adopting these digital IDs, and that there are ways to do age verification that are actually more privacy protecting for adults than in the real world, because a third party who's conducting it that is not actually transmitting any of this information to Pornhub itself. And so if Pornhub were to have a data breach, there would be no information there about the user other than that they were over 18. So anyway, that's my pushback. I realize that's not every state, but I do think that this technology does exist now to do this privacy protecting.
Yeah, I think Louisiana is a really good example. I think some of my disappointment in this decision is maybe just that the regulation here perhaps jumped the technology. And I think this is very much an evolving, emerging space. And it feels like states are going to retroactively go back and maybe create some guardrails or do some innovation about developing ways to do this.
So go ahead, Ash.
I'll be really fast. In the Denver consortium, the Supreme Court was looking at cable requirements for cable subscribers to affirmatively request access to adult channels, and struck it down because it basically was talking about even though that still is chilling speech. So I think the question here is, and again, I thought the Supreme Court was going to say sometime down the line, we're going to assess if the technology is there, but we didn't even get to that because they didn't apply strict scrutiny. Jennifer, back to you.
I was just going to say, I think this is an emerging and evolving space, kind of sums up also where we are in this debate over age verification right now. So I want to thank you all for being a part of this conversation again. Needless to say, this is likely to be an ongoing conversation. As was mentioned, there are other cases that are working their way through the courts around related issues like age-appropriate design codes and age verification more generally. So I'm sure that we we'll be having this panel of experts back to discuss similar issues as relates to the balance between protecting young people online, free speech, and privacy. So I just want to take this time to thank Ash, Bailey, and Claire for joining us today, and to thank all of our listeners to this Regulatory Transparency Project podcast.
Awesome. Well, I'm going to throw that one back. And thank you so much, Jennifer, for moderating. And thank you again to Bailey, Ash, and Claire for joining us today and for sharing your very thoughtful insights. Thank you to our audience for tuning in today. And if you're interested in learning more about all of our programming here at the Federalist Society and with RTP, discussing the regulatory state and the American way of life, please visit the RTP website at regproject.org. That is regproject.org. Thank you.
On behalf of the Federalist Society's Regulatory Transparency Project, thanks for tuning in to the Fourth Branch podcast. To catch every new episode when it's released, you can subscribe on Apple Podcasts, Google Play, and Spreaker. For the latest from RTP, please visit our website at regproject.org. That's regproject.org.
This has been a FedSoc audio production.